In this chapter, we will look at California's judiciary, politics in the courts. California's judiciary shares power with the legislative and executive branches. As in other states, it is divided into two levels, trial courts and appellate courts. Lower courts handle major disputes and offenses and hold preliminary hearings on more serious matters. Trial courts decide matters of fact, appellate courts matters of law. All cases are either criminal, wrongs against society, or civil, disputes among individuals and/or organizations. California's courts have a national reputation for independence from the federal judiciary. California's independent state grounds doctrine assumes that when state and federal constitution provisions are similar, California should interpret provisions more expansively or liberally. And they've done it on issues such as the death penalty, financing of public education, and fair housing. It's sort of a judicial federalism, the ability and willingness of different court systems to produce diverse, fragmented, and contradictory policy. So in this case, Californians can, in many cases, shop for the level they want to get the desired result. How are California's courts organized? California's court system is the largest in the world, more than 2,000 judicial officers. As we've mentioned, it has three levels. Trial courts are superior courts in the counties, appellate courts, and the Supreme Court. Trial courts are the lowest rung and are the triers of fact. They determine who is right or wrong in civil disputes or who is innocent or guilty in criminal cases. They also serve as family, juvenile, and probate courts. These cases can be decided by a jury or only a judge. Trial courts handle more than 9 million filings annually, mostly criminal, and as your text notes, the three strikes law has had a dramatic impact on trial courts. Appellate courts are the next level. They hear appeals from superior courts and also from quasi-judicial state agencies. Geographically, they are divided into 6 districts, and they decide questions of law, not fact. They ask were legal procedures applied properly. There are no trials and no witnesses or juries. Justices will read trial court transcripts and sometimes hear oral arguments. Appellate court rulings are often final because the state Supreme Court doesn't take a lot of cases. It's very selective about the cases they take. Appellate courts process about 11,000 matters annually. The Supreme Court is at the top of the judicial system. Its purpose is to raise important constitutional issues and maintain legal uniformity throughout the state. They are selective. They average about 100,000 filings annually, but only issue about 100 written opinions. The 7 justices spend most of their time in legal research and opinion writing, and only hear oral arguments 1 week of every month they are in session. Much of the Supreme Court's work is civil, reflecting legal problems of California businesses. They also hear automatic appeals of death penalty cases. Death penalty cases must be heard directly by the Supreme Court and not through the appellate court system. They also deal with interpreting initiatives which foster litigation and ultimately the court's interpretation. Now, how do you become a judge? First, you become a lawyer. You also can see the other steps in the process. Today, courts remain largely white and male, and a major challenge in our court system is equal access to equal representation. Become a judge, you also need a network of personal, legal, and political contacts. Also in criminal law, aspiring judicial candidates also are likely to be district attorneys and not defense attorneys. How do we select judges? California selects with what is known as the Missouri Plan, and that combines both elections and appointments. The system is based on 2 assumptions. 1, that fellow lawyers can best assess the attributes of judicial candidates, and 2, that in a representative democracy, ultimate accountability to the voters is important, even for judges. Voters elect trial court judges for 6-year terms, and they run in nonpartisan elections. their re-election is virtually guaranteed. If a judge leaves office before the term expires, the governor will appoint a replacement to fill out the term based on recommendations from the local bar members and political allies. As you can see, elections are rarely combative. For appellate and Supreme Courts, it's a combination of initial appointment and later election. The governor makes the initial appointment with the input of the two groups you see on the slide. Voters will then have their input in the next gubernatorial election. In retention elections, there are no specific opponents, and the judge runs only on his or her record. Supreme Court justices face all California voters. Appellate justices only face the voters in their respective districts. They serve a 12-year term before facing another retention election. How are justices disciplined? Justices can be impeached for misconduct in office. There's judicial accountability, there's peer review, and they also can be voted out at the ballot box. How do courts make their decisions? To make decisions based on the concept of adversarial justice. There are some infractions that involve no jail time. Misdemeanors may result in time in a county jail, and with felonies or more serious crimes, they could be sentenced to state prison. There also are wobblers, or people who commit felonies that judges may reduce to misdemeanors under certain conditions. Let's go briefly over the steps in the criminal process. In the pretrial process, you have an arrest. The district attorney makes a decision to prosecute. If so, an arraignment is held, then a preliminary hearing if it's a felony. That determines if there is probable cause to hold a trial. If so, there's an indictment. And also before trial, that's where you see plea bargaining. Well over 90% of criminal cases are disposed of before trial through the plea bargaining process. At the trial itself, the prosecutor and defense attorneys give opening statements, then the prosecutor presents evidence for the case. Defense attorneys can cross-examine the witness, then the defense presents its case. You then have closing arguments. The judge can instruct the jury, if there is one, and then the jury deliberates and renders a verdict. If the accused is found guilty, the judge will determine the sentence using state-imposed guidelines. Generally speaking, judges are guided by the determinate sentencing law that sets finite prison terms. In the civil process, more than 90% reach disposition within 2 years. In the pretrial activity, there is a complaint, the discovery process, depositions, and interrogatories. In civil cases, there are efforts to settle them before they go to trial, and the vast majority are settled out of court. The civil process is similar to the criminal process. Though you need 3/4 of a jury to agree for a verdict to result. Part of the verdict could be a judgment, whether wrongs were committed, who is responsible, and what damages, if any, should be awarded. About 10,000 jury trials take place each year. There's a concept known as popular justice. That's where juries selectively interpret information in light of their own experiences. In jury nullification, individual jurors or entire juries follow their conscience rather than the law and evidence before them. Many believe that was the case in the O.J. Simpson trial. Courts can do policymaking, and you can see some of the concepts involved in the policymaking aspect. California's courts have changed in policymaking over the years, from the liberal Byrd Court in the 1960s, which believed that the courts were a change agent to problem solving, to the less activist and less assertive courts since then. Social trends also have a significant impact on our judicial system. We see a rise in young minority males who are statistically contributing more to their fair share of street crimes. We see widespread use of handguns and assault weapons. And of course, we see drug and alcohol use contributing to cases in the criminal justice system. Let's look at sentencing mandates. In 1976, California passed the Uniform Sentencing Act, which set specific sentencing ranges within which judges can work. The Three Strikes Law in 1994 called for 25 years to life sentences for anyone convicted of a third felony, whether it was violent or not. Under Prop 36 of 2012, life sentences were reserved for those deemed serious or violent. Let's spend a moment talking about capital punishment. In 1972, both the U.S. and California Supreme Courts ruled the death penalty unconstitutional. In 1973, the California legislature reinstituted the death penalty by adding special circumstances under which it would be employed. Death penalty cases are bifurcated or divided trials. The first stage determines guilt or innocence. The second stage determines the appropriate sentence. There also is talk about corrections reform, since prisons are overcrowded and the system may not be run as efficiently as it can. Why? A few reasons for costly and ineffective incarceration. Longer sentences, higher levels of recidivism, and obviously the longer inmates remain in prison, the more costly they are. Finally, the California Judiciary manifests itself in trends seen in California government. The legal profession doesn't mirror the state's growing ethnic and cultural diversity. The judiciary is clearly affected by the state's diversity, and access to our system is problematic, especially for the poor. Please use this PowerPoint as well as other information in your course documents folder as you prepare for your weekly quiz. Good luck.